Morning, everybody. Welcome to the 54th edition of Cannabis Live. From the Cannabis Legal Group, I'm Craig Aronoff.
Travis Copenhaver.
Welcome to our show. We have a lot going on here in Michigan.
Especially in this last week. It's been a whirlwind.
It really has been. We had a board meeting yesterday. Exciting news came from that. We had new medical conditions added to our marijuana patients. 4 advisory bulletins issued since our last video. Yeah, and speaking of last video, again, we just want to reach out and say thank you very much to Director Brisbo for your time, your patience, your willingness to really engage the industry and to talk between you and David Harns, the communication director. We really appreciate all the work you guys did to help us make that such a great interview. We've gotten some great feedback from our colleagues and our peers in the industry, and we are glad that your voice was heard, and we hope to have the opportunity to do that again. If you wish, you can see our past videos. Bottom of your screen, you'll see the YouTube link. We also keep our up-to-date page for our municipalities on our website, which the link is right there as well, cannabislegalgroup.com/municipalities. So, like us, share us, ask questions throughout, as we always will. We'll do our best to answer those live during the show. We do very much appreciate our watchers and our viewers from last week and being so...
Yeah, and if I may, one of the things I'm the most proud about when we're doing these videos is how respectful everyone is. I know that there's a lot of frustrating things that can be perceived when we're in this marijuana kind of new world here in Michigan. And we truly appreciate that as we're doing these live videos, that the types of feedback we get are respectful of the topics and guests we're talking to. So thank you for that.
Yeah, no doubt about it. And I think that's what helps us actually be able to do those interviews. And, we're going to continue to bring on industry people. We have a few other, great shows lined up in the future in the coming weeks with some, additional guests on some topics that I think we'll find to be very pertinent to this emerging market. When we say emerging, literally, we got licenses.
Yeah, we're so close to having a market. We're missing a very important license type, but we're 4 out of 5.
But that's coming. A couple more made it through pre-qual yesterday. So
congratulations to everyone who made it through, and good luck on readjusting and addressing any of the issues if you were unfortunate yesterday.
Yeah, and certainly we're going to go into depth into the board meeting and some of the discussion that was had with the board members on particular applications. Not really naming them, just so we better understand the concerns that were raised. And I always view, and we've talked about it in the past, that every one of these board meetings is a new data set, a new piece of information. There's never a moment where you're not learning something from how this board is dealing with licensing. And so I think there's some tidbits of advice we can offer from that, just in terms of making sure your application is complete and able to make it through this process. Before we get into, I think, the board meeting, I think we should address, some good news on the patient front, and that is the approval of 11 new conditions for medical marijuana cards. So why don't we talk a little bit about that, if you don't mind?
Yeah, so while there were a few conditions that would have been great to have made the cut, the 11 that we get, there's some very, very big ones on there. And I won't list them all, but 2 that I'm impressed by our state for including would be autism and arthritis, and then chronic pain. Before, chronic pain was kind of tied up in being a symptom to one of the other types of conditions. Now, if you have severe and chronic pain from anything, if it's severe enough, that can in and of itself be a condition. And one of the things I hear all the time when I'm going to local municipalities and talking about why they should opt in and support medical marijuana is this kind of pretty blatant concern about, well, everyone has a card for pain. Well, yeah, because one of the best things medical marijuana does is help treat pain. Yeah. So it's not surprising that severe and chronic pain is one of the bigger types of issues people use medical marijuana for, because it's really good at addressing that. We have some...
no doubt about it. And Jamie, thank you for Go Michigan, Yay Autism.
And your personal... I'm sorry, I didn't talk about it. And your personal efforts to work on that. We appreciate it.
Yeah, if anyone's been watching, Jamie's been an amazing advocate for the industry as well as for getting this change to our medical conditions for treatment and options for children with autism. So thank you for those efforts, and great job for everybody that was involved with that. It's great. Yes,
you might see her behind us here.
Yeah, she might wonder about it. So that was one bulletin, and so there are a number of other conditions that were on there. study it up. If you want to learn more about the industry, you can go to michigan.gov/medical marijuana, and the bulletins are all there. And again, as we do every week, we encourage everyone to stay educated, follow through with what the state is offering. They've done a great job, as always, to communicate with us in the street and to provide these bulletins.
And something to keep in mind as well is, none of this is permanent. Just like some of these conditions didn't exist until July, there's always an opportunity for more types of conditions to eventually be included in Michigan's program here.
Yeah, and so, over time, if there's advocacy that requires it, I think one of the things we're going to do is we're going to bring on a physician in the not too distant future to talk with us and, give us more of a medical background and how they view it as a provider that's going from what was this, caregiver-patient model, not a lot of consistency in the delivery of medicine to not knowing exactly where to send their patient, to this commercial market where I think they're going to have trust and confidence in the medicine provided.
I think one of the real advantages of the MMFLA once it does get up and running is, more and more physicians might be willing to recommend the use of medical marijuana when there's some sort of standardized assumption of what those products actually look like and some verification that they are in fact treated with
conditions that make sense. So the more conditions we can put into that, in California, I think in Oklahoma, even the more recent ballot initiative they had, doctors can decide if it's helpful for their patient regardless of the condition. So it's up to the physician to decide the treatment plan, not the state to limit it. But, hopefully Michigan is on its way for that, and we'll get there eventually. We had a couple of other quick things to discuss.
So like I said,
advisory,
Like I said, there are 4 of them, so we'll kind of go through them quickly, and if anyone has any specific questions, we're happy to circle back to them. A few of them were, reminders to processors talking about the different requirements you have under the rules and some suggestions for things to look out for based on some of the data LARA is starting to see. We have another round of what LARA is calling tips for licensees with examples of what to do, what not to do, kind of trying to give some context and explanation to the rules themselves, very similar to the first one they did.
Yeah, key is packaging. You can't make it something that's attractive to kids, and you really can't see the product through the package is the goal with most of that.
Yeah, a couple outlines clarifying things safety compliance facilities will need to do. A little more technical unless you're actually in that space, but it's pretty short, so definitely worth a read. And then the last one that came out on July 5th really is about sanitation. There were a few jokes made.
Yeah, don't lick the marijuana.
Yeah. But beyond the humor involved in that, it does make a lot of sense. Once you're creating products for commercial, a market, it is a medical market, but it is still commercial. It needs to be professional. Just like you shouldn't be, putting a human tongue to a product that's not sanitary. You need to, you can't touch food with bare hands and lick food. Why would you do that to other products that are going to be?
And all jokes aside, if we're talking about pre-rolled joints, oftentimes people recall licking the paper to get it to stay shut. That is exactly what we're talking about. You can't lick the product. You can't lick the materials or the packaging. So, again, be smart, common sense type of things. I think, again, the state is doing a good job of kind of creating the regulatory framework at the same time that these rules are being more formalized and go from the emergency to the finalization of those rules.
And once we get past a lot of these application-specific, technical, operational type bulletins, you're going to expect to see a lot of things like this. We had the one about, what was it, the outbreak of...
Hep C.
Hep C.
Hep A.
Forgive me, I should have prepared for that. These are the types of things you'd expect a regulatory agency from the state of Michigan to ensure, operators are thinking about.
Yeah. Well, again, just keep reading up on it. If you're going to be an operating licensee, these are things you must know. So there's no may involved. It's not optional. Read these and operate in accordance with the state rules and regulations. And a comment that we can talk about is, flipping to the board now, because I think that yesterday's decisions and how they kind of discuss those decisions go in line with the changes we're seeing from LARA. There's this ever-evolving adjustment, not only in the process, as Director Brisbo talked about last week, internally at LARA, they are creating more efficiencies for themselves. They are learning their process better. They are ever evolving and taking, constructive criticism from the industry and trying to find the best way to do this. The board, too, I think we have to give the flexibility to say they, too, are getting to know each other, getting to understand the way they operate together,
learning what their powers are, what they aren't,
and how to really engage one another. And I think we're seeing that maturity with each one of these particular meetings. While we might not love everything we see, and we wish it would go faster, and we have our desires to see this market move quicker, you know what? It moved from 0 to 4 licenses yesterday, and so that's a great start.
I don't think it's surprising anyone based on the last several months that things are moving at this pace. While that can be frustrating, as Craig mentioned, it's not unexpected.
Right.
Similarly, a lot of the conversations that occurred about these different pending applications weren't too unexpected either. It's a lot more of verifying the same types of concerns and addressing the same types of issues that have been problematic for other applications that have had problems in the past.
Absolutely, and I think just looking at the numbers, there were several 5-0 votes.
Mm-hmm.
So let's not throw everything out with the with the bathwater here and say that there's one board member who's always not, but no, there are some that are 5-0. So
I think at this point we've had every one of the 5 board members make the motion to approve at least once that it's gone through at this point. So even if you identify one specific individual out of those 5, all of them have supported applications. So you can't say in good faith that they are doing everything they can, whoever those people you might identify are, that to derail or prevent this. It's just the concerns of each board member are being reflected in the types of decisions this board makes as a whole.
Yeah, no doubt about it. And fortunately, we had several 5-0 votes, and again, I think that the key to those were complete applications, full disclosures, waiting for LARA to ask a question of something rather than disclose something that you likely should have, is where that line in the sand is starting to get drawn. Because they're trying to redefine and help us understand what intentional failure to disclose is versus a negligent failure to disclose.
Right, and to be fair, they are kind of charging this path as they go, right. And that might catch a few people in the unfortunate position of not being the one to benefit from the knowledge that others are going to get after the fact. But, they are not really kind of deviating from some of the precedents being set. Yeah. If anything, they just provide more context, clarify for that.
Well,
in
some cases, while I appreciate that statement, I'm worried that for those that are looking to appeal and those that were denied, the record from the board and the discussion of the board to fully understand the reasoning for the no vote so that you can go and find the evidence to show why that no vote was not correct and, go through that process, it would be better if it was developed further. And so from an evidentiary standpoint, understanding the appeal process, it would be great if we got a full understanding, for instance, why one of them voted no, even though he didn't speak at all during the entire
There are several instances of people ending up with no votes that really didn't discuss why. And again, we don't get to see the written record. We only get to see the record that's discussed between board members. So we have to remember, if we're looking from the outside in, we don't see the full picture. There might be plenty of information to support a yes or a no that is never discussed and therefore never public knowledge.
There's a question in here that I want to jump at, and I know it's a little bit before we were going to talk about it, but it was relating to Part 2 having to be received by the state by September 15th. Or you should close. So if you're a temporary attested operating entity right now and you don't have your Phase 2 in yet, what Director Brisbo very clearly said yesterday was if it's not in yet, it's very unlikely they'll ever get to it before September 15th. So that is going to be an issue. So if it's not in yet and you're operating, you need to get moving on it just to have a chance at having it submitted and reviewed by that September 15 date. Right. Every indication that is coming from LARA is there will be no extension, that this is a firm date, and that if your Phase 2 isn't in and reviewed by the board by then for your pre-qual approval and I guess your Phase 2 approval, then those entities are going to have to close down temporarily, wait out the process like every other applicant, and then reopen upon licensing. The other thing to keep in mind too, of course, is that those that receive a license no longer can utilize the old system. They need to operate as a licensee with seed to sale tracking, with tested product.
So, for example,
properly labeled products.
Right. If you were temporarily operating and you get the right to pay your regulatory assessment fee and get your license, the minute you have a license, you have to meet license requirements. Temporary operation under Rule 19 only kept, and this was stated directly, the board from using any of that knowledge created against you in the evaluation of your approvals.
Correct. They weren't authorizing you to be a licensee. They weren't authorizing any of that. And so that seems to be the indication. We can debate what the rule says.
Right.
In fact, we can get probably
There's
a
several
whole show
rules.
about that particular. I mean, if you look back, we have talked about Rule 19 in the past, and both some concerns over the ambiguity that it creates, as well as how people should rely upon it, or maybe not rely too much on it, and just try to don't push the envelope. And talking about don't pushing the envelope, I think another area of discussion yesterday was relating to promotion of recreational.
Yeah, and we had a big chat about that before we started recording, which we probably should have just started recording.
No, it was a very healthy debate between the two of us. And as you guys have seen in the past, we don't always agree on everything. We do have a very, I think, common view of this industry, and our advice is very often in queue and lockstep with one another. But this whole promotion of THC being something of critical concern by the board, I think that there's a line where it pushes the envelope and we should know better. And then there's some other areas we should be free to have your First Amendment right to promote what will be a ballot initiative in Michigan.
So let's break that down a bit since we brought it up. I mean, we don't know for a fact, except unless it was addressed at this board meeting, what the actual promotion at issue was. So there's a big difference between, promoting, recreational marijuana in a way that wouldn't have some sort of implication for your operations, and promoting recreational marijuana in a way that makes it look very blatantly like you are literally offering services outside the scope of the law.
So I think without the specific, applicant that did it, and without going into that, but there was some discussion between, what was on a website, for instance, and actually marketing what was both, quote, medical and rec marijuana versus maybe participating in a cannabis cup, which again raised some concerns, and quite frankly, there was pushback by a number of those that talked at the public session after, that in Michigan it's always a medical cannabis cup. I think from my perspective, in phase 2 you got to provide your marketing plan, right? And so we got to tell the state what we're intending to do and how we're doing it. And so they are looking back at your past marketing. This is an area where you can show if you participated, what your materials look like and how you participated. Again, give them the information so you're answering the question before it ever got asked.
Right.
And now that we see how they're asking those concerns, we have the ability to provide that.
Right. And this got brought up very blatantly last week when we were talking directly with Director Brisbo. You need to explain yourself. If there is evidence that could objectively be read in a negative light, it would behoove you to, explain it so that they don't read it in a negative light to the extent that you can. Right. If you participated in Cannabis Cup, well, okay.
And we're not critical of that.
Not at all.
Great. It's something we're allowed to do as caregivers. Up till now, you get to test your wares and show the patient market what your genetics are, what your product line could be. As we move from this old caregiver-patient model into the commercial market, we too will be able to show how these brands can exist and the different product lines. And this is a great way as an expo for the industry to engage itself. Right. But it has to be done within the confines of Michigan law.
Right. And I think here's the lesson, not about Cannabis Cup, but just in general. If you were doing something, and you're not going to get the benefit of the doubt. So, if there's a way you could construe any of that information in two different directions, it might behoove you to explain it why you were doing what you were doing was okay, regardless of what that conduct was.
Yeah, and we saw kind of a mixed bag as far as how the board reacted to it. Generally there was the one that was critical, but that criticism made it through on a couple of the applicants. It wasn't just being an isolated incident. There was some split votes yesterday, and quite frankly, there was some denials that we're disappointed to see as denials. It would be better to understand and fully clarify what the concerns were, but some of them, the way they talked, if you're showing tax records with limited income and you have bank records with lots of money flowing through, 1 + 1 has to equal 2 at some point.
I mean, it's pretty instructive, and it's nothing new. It's disclosures, and we don't always get to see what that actually means. But one was referenced, we had a tax return indicating what income was supposed to be, and we had bank statements that didn't seem to make sense, given that you're claiming this and this is what we see. Now, maybe it did make sense. Maybe there was some explanation that was perfectly valid for why things looked that way. But if that wasn't provided to them, they're not going to just assume you did it okay, right?
Right, and I do take issue, and I do appreciate some public comment again at the end that there are people that can be in this industry as ancillary consultants that will help the industry thrive because of their experience and knowledge. Just like if you were a business consultant helping a business with its, lean systems to help, move itself into a more efficient process, or a computer consultant or something along those lines. In this industry, we have growing consultants, we have process consultants, we have people that understand the equipment and the way to do it, and they shouldn't be excluded from the market. But in the same vein, as you're applying for this license, and if you have made money in that respect in the past, you really need to maybe add more data to it.
Right.
Again.
And here's an important
that up also.
Right. And this isn't about anyone specifically, but here's the problem. If you've received income, I don't care from where, it needs to be reflected on your tax returns. So if they have indirect evidence showing you had more income than you were claiming, you should clean that up. You should explain it. Or you should take some remedial action to fix that.
Well, and we also have, that they very clearly have said throughout that, if we have larger deposits in your accounts, or if you have transactions, so it doesn't have to be a deposit, it could be a large withdrawal as well, that they should be explained. A spreadsheet that just says this was for that expense, or I bought some equipment, or, and here's the money returned, or whatever it is. Again, they're kind of feeding us the opportunity to provide this information without having to be asked about it. Right. And so as we go through and it is, people will say it's a very deliberative process to get your file out, this application properly filed. We're seeing from some of the early ones, some of the mistakes that they've made, right? And so maybe, expecting, well, I'll just wait for them to ask me for it, then I'll follow up with a deficiency disclosure. So if they don't ask, I don't need to. Wrong. We're finding that's not the approach. And so this experience that we've seen now has given us the ability to kind of take the time with the file so that we know that those kind of transactions that could be subject to questions are being addressed. Right.
And luckily, if you aren't to this stage yet, like some of these other applicants have been, you get the benefit of learning how to do it better than they had the opportunity to do. I think that was even mentioned in a public comment. So, and I do think the board's starting to see that a bit too. Right. But that doesn't mean, if it says objectively you needed to disclose it, things need to be disclosed.
Right. And I think that, people really need to think back. Did I get arrested in 1969? That came up yesterday. And, as I've talked to clients too, you're asking for a license. If you ever had a time to sit back and say, I'm going to turn off all the noise around me and I'm going to really think about my history and whether or not I ever sat in the back of a police car or ever had those cuffs on or ever had to be fingerprinted or ever had an arrest that I should be worried about. This is the time to disclose it, whether you can find the record or not. Put it down.
That's a great point. I mean, if you're an applicant or a supplemental applicant, you are under significant scrutiny. I'm not applying for a license. I might have something I don't have to think about because I'm not on one of these applications. There's plenty of sources where someone mentioned an iChat. iChats are a great, double check, looking up records and things, but they don't collect everything. Yeah. iChats they depend on accurate records. They depend on public records. If something's been sealed, expunged from juvenile, it's not going to show up there.
There's people maps. There's a few different products. Sure. And, we as you can imagine, we've asked, we've tried. We're trying to find the same sourcing that the state uses so we can get the same kind of comprehensive, response, and it's just not available.
And that's because they are the state of Michigan. Right. They're going to have access to data that the private sector is not going to have access to.
So in that vein, what we have to do is try to utilize all of the available tools. The FBI offers an FBI national search. Locally, if you lived in Michigan, iChat should help. There could be a couple of other sources locally. If you're from another state, they too might have some system statewide that you can leverage. But the key is that you got to work with whoever you're doing it with, your representatives, and find those sources if you're really not sure. We also know that an explanation in a letter form is acceptable to the state. And so, to that end, if you've been, if you've had an arrest in, let's pick a city around town. We're in Royal Oak, Michigan. Royal Oak's records, and Nick makes a point that they don't update their records, frankly.
I'm going to try something here. Yeah. Just an experiment. There, now you can see it.
Right.
Sorry, we still are learning our technology right now.
Yeah, no, that's cool. So, and I think that the point is that, we've gone to the courts themselves, we've asked for the records, and then we can write a letter that says, I was arrested in 1984 in Royal Oak, Michigan. I've contacted the court to my best efforts. The records aren't available. I believe it was for a traffic incident, and this is what happened. And at least you put the disclosure out there, because they're not faulting the people that have disclosed things that, are, they might not like it, but they're disclosed. What they're faulting is even as innocent as it might be, the failure to have disclosed it.
Right.
Even if you thought it was a traffic incident and there was no misdemeanor associated, and you read the rules to say you really don't have to disclose that, this is where you probably should anyway.
Right. And here's the thing you need to keep in mind. No one's going to know this history better than you. I didn't live it. I can help you track down those records. I have experience, my team has experience finding legal records. But if I have no idea, I need to look for a certain thing, it's going to be dependent on the applicant and the applicant specifically to give as much indication as you can about what happened. It's better to send LARA on your application. I might have been arrested when I was 18 in college in the year of, 2000.
You're young.
That's younger than me, or older than me. I mean, I was trying to be meet you in the middle, right? But no one's going to know better than you, and maybe there's nothing there. But having that statement on your application means that you tried. So maybe you were a little off, but if there's records that reflect, in your application that you weren't trying to withhold it, you just literally can't remember, that's going to be treated differently than if LARA finds it and then asks you about it. And maybe you still have a good reason, like maybe it was from the 60s and it never amounted to a charge, but,
Right. And that's just great advice. Again, it's just kind of clients might get frustrated with us because we keep asking and asking and asking. It's because sometimes on the fifth request, we get a different answer.
Right.
And that's what that is us making sure that these questions that we know will be asked. We already have discussed, some concerns of what LARA will be asking for of existing entities, caregivers. We need to know from your financials that the sales that you've made match up with those that are going to be available by the applicant storefronts that have that data showing who their caregivers were. So there's a bunch of different nuances to all this information that we really just got to tread cautiously on. Another area that we saw from great concern of the board was the CPA attestations. Mm-hmm. We actually saw the question of, it looks like they have just enough money for us to say yes, but will we be able to revisit this in phase 2 when their actual team is being identified, the staffing plans, the employment plans, the facility itself, and whether or not they have money to build what they say they can do. It's one thing to say you have $500,000 for a Class C license, but do you have $1.5 million to actually build it?
Right.
Because that cost will be a hard cost to the company. And so they're going to start looking at your math phase 1 to phase 2 is another piece of it. So your CPA attestation, it needs to be clear that you have the capital to do this, not only from the source for the capitalization, but also for the rest of it.
Right. And I think that needs to be emphasized. Even though in conversation, we treat step 1 and step 2 very differently. This is one application. And step 1 is not finite. It does not end. If you have a big, important decision when you start with a step 1 and then follow up with a step 2. But as things change, as you actually start moving forward, those records and those new people and those new ideas need to make sense reflected to what the state's already looking at.
And even then some of the question was relating to how the state is going to receive its taxes and the forms and so on. And you're right, the state is still maturing on that. Short version of it might be eventually they'll allow the secretaries of state possibly to receive those funds.
Maybe a secure transport even. They might get creative with ways to
so that we can get it in. But bottom line is that as the state matures, these type of issues will kind of sort themselves out. Thank you for asking that, Kathy. But kind of going back to the greater picture of the financials and the comparison of phase 1 to phase 2. Another reminder is that phase 2, if you submit phase 2 and you're in with the phase 1 and phase 2, you're in with phase 1 and phase 2. There was one of them yesterday where the board really wanted to go back to the pre-qual and allow the phase 2 to kind of prove itself out a little bit because I think there were questions on the ability to actually meet its financial goals. And the Attorney General's office said once it's in, it's in. It's all or nothing.
This is not 2 applications. This is 1 application.
Oh.
And most people have submitted half of it so far.
Right. And many of those temporary operating ones have not submitted the second half, which, again, is going to prevent them from actually likely being heard before this September 15 cutoff. So we have this catch-22 that's going on right now, which is we want to get pre-qual to know that the team and the who is okay, but the where and how you're operating is suddenly becoming more and more important if you're operating already. But even if you're in the position to say, hey, the local community said it's okay, I'm ready to submit my phase 1 and phase 2 together, just understand if there's any questions on that phase 1, it might be best to hold off the phase 2 until you know for sure on the pre-qual. Why? Because the phase 2 will get denied also. Right. And that's what we want to avoid.
Right. So maybe we should transition into running down some of the data LARA provided us at the end of the board meeting here, just because we're getting towards the end of our show today.
Of course.
So we did get some updated numbers. There are 594 paid and submitted step 1 applications in the queue. That would include 121 growers, 16 Class A's, 4 Class B's, 101 Class C's. We have 37 processors, 114 provisioning centers, 9 secure transporters, and 6 safety compliance facility applications.
And I think that was in 97 opted-in communities. Keep in mind, we have 1,700 communities around the state of Michigan. Yeah. 97 is the number that we currently have. We're not even at 10% yet.
Now, we are aware of several municipalities that are still working on or might even have some ordinances passed over and above 97. I think they're getting that data from applications they're receiving that are citing to certain municipalities.
Yeah, it likely is a slightly higher number, but there's also a number of communities that now, due to the ballot initiative, are saying, we'd rather deal with this once, not twice, and trying to put the brakes on their process.
Which is fair as that may be. Just a quick reminder to municipalities: for most of the licenses anticipated under the recreational ballot, one of the requirements is that those applicants have some sort of medical license to proceed. So if you are waiting but do think that there's a possibility you'll want facilities in your community, delaying medical is only going to further delay recreational licensing in your community.
And I think they can kind of contemplate an ordinance that does cover it. But notwithstanding, I think that does drive in a separate point, which is, and I'm going to defer back to what Brisbo said to us last week, that a number of communities require phase 1 to be completed before they'll review the local app. And as I think he indicated very clearly on the record for us yet last week, that's not what the state wants. It's not what the state anticipated. And quite frankly, I think a lot of our advocacy is to go back and try to push back on communities because they need to get the where down. They need to figure out the zoning. They need to allow people to commit to property and allow that portion of the market to begin to move.
And no one's saying municipalities shouldn't have some sort of actual operator, check and approval. They do have the right to take a look at certain people. But watch any one of these board meetings and ask yourself, are you worried about someone who can't get through this process? They need to get approved at step 1. And if they can't disclose very, very large amounts of information, they're not getting approvals. We've seen that multiple times over. If you can get through a step 1 process, there is not anything in that person's past or that team of operators' past that's going to be something objectively problematic for your community.
But I think also, people are paying $6,000 to apply. Just show you have the application in.
Right.
That is a big concern of ours because I think what we're going to run into is this logjam. The state is only moving so fast. We had 19 yesterday or something approved. That's just not enough. That means that there's only roughly 100 people, or not even, there's roughly 35 people out there that can actually go to some of these communities that have waited with this pre-qual and walk in and say, I'm ready today, and be in front of other people who may have been submitted for 3 months, and it just doesn't make sense.
And the Bureau said several times a big reason for this delay is municipal level stuff has not gone as fast as they anticipated. And I respect the fact that municipalities don't want to be in this position to go first, but that's the way the law is designed.
So and again, this is anecdotal to the board meeting itself, but if people are waiting on their community, part of what we want to do is begin to advocate back and try to talk about how the licensing board and LARA in particular from the Bummer Bureau are actually wanting these communities to move a little faster than doing these pre-quals. So if there's any evidence that we can show them, you can look back at last week's video and maybe take that piece from Director Brisbo to these communities and say, is there something we can do to soften this so that we can actually close on the deal? and lock up and create
Right.
the buffers and begin to move these markets rather than wait out what could be literally 6 more months of people sitting on their hands
Right.
with contingent deals. So again, as you see, as every step forward, we got a step sideways. But that's just our commentary on it. I'm sure others have similar concerns with it.
Couple of, I was about to list all the things they mentioned.
Yeah.
Here's some some other things. There continue to be problems with applications missing bank statements, not just tangentially related bank statements that get pulled in, but actual personal bank accounts. You need to list every account you have, and you need to list 36 months of recent history for that account. And then there's also statements saying that when these applicants are getting ready for step 2 inspections, they're not ready to actually receive an inspection. Part of that inspection is not only coming to, actually tour the facility for safety and things, but to, see that you're doing all the things you're required to do. You need to build out the facility, install, and start facilitating some of these operational narratives. So, if you're not ready to do that, perhaps you should, get yourself in a position before you're ready to engage in the step 2 step.
Absolutely. There was some discussion on the meaning of temporary operation as well. Again, just be cautious. The MMMA is our only existing law. You're only a caregiver. You're only a patient. Those are the only licenses issued by the state of Michigan thus far. While they even had those that were approved for licensing, they weren't issued yet. They still have to pay the regulatory fee and get into that system. And so again, be cautious, be smart, pay attention to your numbers, your inventory, all of those type of things, and document your sales. I mean, at the end of the day, there's clearly going to be a need for, full transparency of all the financials. So I think we covered quite a bit.
Thanks for hanging out with us today.
we do appreciate it, as we do every week. This was a great week for the state of Michigan. It's a start. We would all love to see it, light years ahead, but we're getting there.
Congratulations again.
Yeah.
I'm sorry. Congratulations again to the first of hopefully many people in a position to get those licenses. They're, technically no one has a license yet. You got to go pay that regulatory assessment fee. So.
That's right. There were 4 staff Class Cs that were issued.
So do you want to mention that briefly? Or?
I guess that we can address those later. But
sure.
It was great to see the state willing to do that. And so,
definitely.
To that end, I guess we'll look forward to bringing you episode 55 next week. I'm sure we'll have a solid, agenda to talk about as we do every week, but we have a few guests that we're working out some timing issues with. So we'll look forward to advertising that and getting that to the public so you know what to expect from us. But until then, I hope you have a great weekend, a great week, and enjoy your summer. So for Craig Aronoff,
Travis Copenhaver,
have a great week, everybody. Thank you.
Thanks, guys.
I got to hit this button. There you go.